today. The webinars that we are holding as the Legal Practice Council, it is to assist you as legal practitioners to be compliant, not only with the Legal Practice Act, but also with various topics that will be affecting you in your career as well as in your offices. I am not alone today. I will be presenting on Rule 54 of the Legal Practice Act. I'm also with Mr. Gert Nel and Mr. De Bruin, who will be discussing the topic on road accident fund related matter. The recording of today's session will be made available on our social media pages as well as on our YouTube channel. You are also welcome and invited to send us an email on info@lpc.org.za. The purpose that we are inviting you to send us an email is so that you can share with us ideas on topics that you would want the LPC to present to you as legal practitioners. We also further ask that you provide us with further suggestions on how we can improve on our webinars. Furthermore, before we continue, I'd just like to announce a few housekeeping issues. Like I said, today's session will be recorded and will be shared on social media pages. The questions will be asked at the end of the presentation. I will present, then after myself, Mr. Nel and Mr. De Bruin will present. You are welcome to type your questions in the Q&A column that is provided, whereby a facilitator will ask the questions which you have typed, and the questions will be answered. Now, like I stated before, I will be presenting on Rule 54 of the Legal Practice Act, which is the accounting rules. Now, in as much as this rule says accounting rules, I want you to understand as a legal practitioner, one that will be running their own law firm as the director or co-director, or as the advocate that will be practicing with their own trust account, that this rule does not solely deal with the accounting. But also, if you look at the whole rule, which is the lengthiest of rules in the whole of the Legal Practice Act, it deals with the opening of your law firm, how you must go about when you open your law firm, as well as the closure of the law firm. Now, this rule is applicable to legal practitioners who will be conducting their own law firms. Like I said previously, you are a director of a law firm, you are starting for your first time, or you are in a law firm that is existing and the current directors decide to make you a co-director. This rule will be applicable to you. When you are practicing for the first time as a director and want to open your law firm, I advise that you declare this law firm with the Legal Practice Council. By declaring, I mean you must inform the Legal Practice Council in the province that you are currently situated of the registration of the firm. Please do not start practicing or do not start operating this law firm before it has been registered by the Legal Practice Act. This is very important, colleagues. The reason I'm stating that is that most law firms out there, practitioners' careers come to an end or find themselves in trouble with the Legal Practice Council for reasons that they are practicing without informing their regulator. And that is a contravention because it means you are practicing without a valid fidelity fund certificate, which is a criminal offense. So it is important that before you start, you've informed the relevant LPC in your province that you are about to operate your own law firm. Furthermore, what I want to state is that this rule is also applicable to advocates. Now, when it comes to the accounting aspects of this rule, it is important for you to note that you must keep accounting records. By accounting records, we mean trust account records, and we also mean business account records. So you must keep these records of your law firm. They must be readily available. They must be clearly distinguishable. So there must be separate entries for your business account entries as well as your trust account entries. This accounting records that you will be having must be updated and balanced on a monthly basis. This is very important because if your trust accounts are not balanced and updated, you will not be able to account to your client. As the Legal Practice Council, we get a lot of complaints that the practitioner did not account to me. And we will ask that you account to the client, which will be your client, and it must be done in a reasonable time. The accounting records that I am referring to must be kept for a period of 7 years from the date of the last entry or from the date of the termination of the mandate. It is very important. You cannot, when the mandate has been terminated or the mandate has been completed this year, disregard the accounting record and disregard the whole file that you have for your client. Because the person can come back 3 years from now, 5 years from now, and request something and come back to the LPC based on the fact that you didn't account. The LPC will then contact you as the attorney of record or the advocate in case that you are practicing with a trust account to account to this person. This accounting records of yours must be kept at all times on your own premises, unless you have obtained written permission from council that you might store them or may store this accounting records at any other place besides that of your main office. This accounting records, colleagues, I think I cannot stress enough. It must be updated on a regular basis, preferably monthly in terms of the Legal Practice Act, in order to comply with the rule that the accounting records must be updated. Now, the most important factor is the trust monies. And that is the reason why we as the Legal Practice Council is here. We are not that interested in your business account bank statement, but in the trust. And the reason for that is trust funds are sacred. Trust funds are not your funds. They are that of the client up until you have completed your mandate and you are able to account the fees that are due to you. Now, this trust fees must be kept separate from your business account. They must be kept separate from your own personal account. I know that in some instances, people don't understand what is regarded as trust funds. I will make use of a simple example. You are attending to a conveyancing matter, and the purchase price of the property that you have to transfer is paid into your account. That monies must be paid into the trust account and not your business account. That's what we mean by trust funds. The accounting of the clients must be done reasonably, as I've said before, and the trust funds must be kept separately. Now, when it comes to the trust funds, clients may decide to terminate your mandate before you have finished with your work. In this instance, you account to your clients as to what is due to you. You provide them with your statement of account, and then you transfer over what belongs to you. When it comes to this, colleagues, it is important to note that when clients are requesting for a refund, it must be paid within a reasonable time. The same when you have written fees, those must also be transferred to your business account within the reasonable times. So no funds must be kept in the trust account except that of trust creditors. Colleagues, when it comes to the trust funds, as I've already stated, must be kept separate from your from your business account, and the trust accounts must be protected. Now, it is your responsibility as the director of the firm to ensure that there are measures in your firm to ensure that the trust funds are safeguarded, that they are safe, it's not accessible to theft by either co-colleagues or by any staff member in your law firm. It is your responsibility that should you have clients that are paying cash at your premises, that this trust funds be deposited promptly. It is your responsibility that when you transfer funds from your trust account to your client, that you verify the account details of your client before paying such funds into the trust account or into the account of your client. What is important to note, colleague, is that under no circumstances can the trust funds in your account be less than your trust creditors. And by that, I mean, if I have to go into simple layman terms, if you have 5 trust creditors and each has paid you 10 rands, you will have 50 rands in your trust account. The moment you have less than 50 rands, you have a problem, colleagues. The reason for balancing every month is to ensure that your trust creditors are accounted for, each and every one of them. Should it happen in the unfortunate event that the trust funds are less than the trust creditors, this must be reported immediately, not over 2 days, immediately to the Legal Practice Council. In the provinces, we experience situations whereby the theft of trust funds is not reported to the LPC, and the LPC, upon its own investigation, realized that there is funds missing of trust creditors. This can lead to the striking of yourself as a legal practitioner. It's important that you report immediately to the LPC about any incident that could have happened, be it a staff member that misappropriated, stolen the money, or whether you were a victim to cyber hacking. It must be reported to the Legal Practice Council. Important is that this trust account that you operate, when you open it with the bank, you will inform the Legal Practice Council. The Legal Practice Council will have it on system. And when you submit your trust audit, which I will cover this topic later on, it is important that the audit should be conducted based on the trust account you provided with the Legal Practice Council. Should you decide that you want to change your details of the trust account, you must inform the Legal Practice Council of the details that has changed. Should you decide that you want to have an additional trust account, you should also inform the Legal Practice Council of the additional trust account. However, each and every trust account that you have must be audited, and the audit, therefore, must be submitted to the Legal Practice Council. It is your responsibility as the director of the firm, as a person practicing with a trust account, that you ensure that you comply with the Legal Practice Act in terms of the accounting rules and in terms of Rule 54. There's case law in the Supreme Court of Appeal, the Cheu matter, whereby the one director, and in the Withdrawn matter as well, which was also in the Supreme Court of Appeal, whereby the one director cannot escape liability based on the fact that the other director was responsible for the misappropriation of trust funds. So it's your responsibility as co-director, it's your responsibility as the director. Even if it's the employee that stole the monies, the buck stops with you. Now, when it comes to Rule 54, like I stated, it's the lengthiest of rules. It also deals with the auditing of the trust books. Now, this auditor, when you register your law firm with the Legal Practice Council, you'll inform them of the details of your auditor. You'll also inform them of the financial year end of your firm. This auditor must compile an audit report for you. If it's your first time opening this law firm, you must, within 6 months, provide the Legal Practice Council with an opening audit. This opening audit will cover the first 4 months of your firm's practice. It must be submitted to the Legal Practice Council, and then thereafter, annually, you are expected to submit the audit report. The audit report for most law firms, financial year end is end of February, which gives you 6 months to submit your audit report, which is August. However, the council might require from time to time that you specifically submit your own audit report outside the prescribed timeframes that is provided. When you do decide that you want to close your law firm, you no longer want to practice, it's not feasible for you to be in practice, we request that you notify the Legal Practice Council in writing of you intending to stop your practice. We also request that you submit a closing audit within 3 months of you notifying the Legal Practice Council. It is important for us to note that when you left your firm, your trust creditors were accounted for, and that there's no trust creditors that has not been accounted for in your law firm. The closure of the firm, you must also submit a letter from your bank, which is for the trust account, that the trust account is closed and that there is no transactions that are still pending in the trust account. I thank you, ladies and gentlemen. I'm going to hand over now to Mr. Gert Nel for his presentation.
Good afternoon, everybody, and thank you for the opportunity and thank you for the interest shown by colleagues and members of our fraternity. From my side, my presentation is a bit later on the discussion list. I'm going to hand over to Mr. Pieter de Bruin from RAF to just brief you on certain matters of interest, and I will do a presentation on the items on my list a bit later. But Pieter de Bruin from RAF, thank you very much for your time, and over to you.
Good afternoon, everyone. Can the organizers just tell me if they can see whether my screen's been shared?
Not yet, sir. Let me.
I think it's
Okay.
going to come up now.
Okay, all good.
Just check. Can you see it?
Not as yet, sir.
All right. It says sharing a window. Give me 1 minute and see. I don't know. On the system, it says I'm sharing. Let me say stop sharing. If it doesn't work, then I'll just continue. Okay. Just give me 1 second.
We'll also share on our side so that the delegates can see.
Well, if you have the slides, then it says sharing on my side. If you can put up the shares, then the slides, then I'll talk to them. If you go to slide 2. Well,
Okay.
Whilst you are doing that, I'm going to do 2 things. Many of you would know RAF, some of you may have heard of us, some of you may not know us. In 10 words, we're a non-profit human rights organization focused on protecting the constitutional rights of road users and road crash victims. So we've been working over the last 3 parliaments, primarily looking at legislation, regulation, including RABS Amendment of the RAF Act, etc. To this point. Now, it's not that relevant besides looking at the future. So in terms of statistics, just the tip of the iceberg, and our head of solutions is Professor Henny Klopper, and he keeps the statistics up to date for us. Out of 40 countries in the world, South Africa is the third most dangerous to drive in. Our death toll is not really 14,000 a year as reported. It's closer to 20,000 per annum. So people killed a day, 52 people killed a day. Then 68% of all road accident fund victims are basically from rural areas, and anything from grade 11 to illiterate. Thus, the people that really need support from a system like this. RAF currently, despite all the song and dances about performance and the perception being created in the national press, only 44% of annual claims are completed. So out of claims annually, only about 30,000 is completed, and therefore it grows by about 35,000. And we estimate that the backlog in terms of claim processing is about 500,000 claims. Total cost to the economy is not 34 billion rand, but it's closer to 175 billion rand. Part of the causes, only 18% of the traffic officers per capita, which is a world standard, is appointed. So we have 80% less traffic officers for enforcement than other countries. And then the big one, and there the statistics are meticulously checked on the RAF annual reports themselves. About 12 years ago, RAF per capita processed 34 claims per employee. That has whittled down to last year to 2 claims per employee overall. So the big claims of success and productivity is absolute nonsense. But I'd like to just summarize, and then I'm going to hand over to my colleague Gert Nel. If you can go to the third slide and you can build it, let me talk to it. And the slide is there. I'm not going to necessarily go through it. There are the following which led us here, and some are legal, some are government in nature, some is application in nature, and some is just willful dereliction of duty mixed with incompetence. We have too many crashes. We have about 130 crashes per 100,000 people. The global norm is 6 to 8. That is the root cause of the problem, that there are 20 times more accidents that should happen in this country. Also take into account the RAF system was built, made for purpose when we had 3.5 million cars on the road. We have 12 million now. So you can see the problem. It needs to be nimbler, faster, quicker. Then pre-2008, the RAF was a center of excellence, and even a few years thereafter, but there's been a gradual, willful, specific erosion of the RAF initially to move towards the RABS Bill, and now to implement the RABS Bill through court decisions and orders. Now, the judiciary, whilst one of the 3 pillars of government, is surely not the place to make laws. Then it takes 55 months to process a claim, of which 40 months are waiting time. Nothing happens. Selective application of the RAF Act and many other things, like the non-settlement of future medicals, the wasted time, unregulated costs, from 8 years ago, 160 million rand annual legal cost to the current 6.5 billion rand. Now, I don't have to go into why it is. Those of you doing medical legal work knows. Few claims are contested, therefore there is sometimes higher or maybe oversettlement, but in the absence of anyone contesting the claim is likely to be higher. Then also they settle on the steps of the court. Only 4% go on trial, but all of them go to once the interest is 300 million rand and. And then also, I mean, the RAF's frivolous and illegal litigation against the Auditor General, against other parties, the bogus board regulations, etc. And that led to the RAF where we are now. So that's the context within which Mr. Gert Nel is going to explain the happenings of the last maybe 12 months, but it's in the context of what happened the last decade. So I'm going to hand over to Mr. Gert and the organizers, if you can go to slide 4, please. You can bring up the whole slide with all 6 points.
Thank you, Peter. Thank you for the introduction. I think, you know, the slide presented at the moment is basically a very shortened version and breakdown of the challenges that we as practitioners face in having to deal with the road accident fund. I'm not going to speak too much in detail about the slide itself. I think the listeners or the viewers and participants are much more interested to hear what's been happening in Parliament since about August last year. And to this day, last week, I think, was the climatic turn of events that started in August of last year at the first SCOPA meeting that Mr. Letswalo attended, where the chair of the SCOPA portfolio committee actually challenged them on certain aspects that we as practitioners are facing on a daily basis. But I think with the necessary input and information that we provided, we were able to channel the questions into such a climatic purpose that it actually resulted in what we saw last week. So without belaboring that point, I think what I will do, and I'll maybe ask Peter to give a bit more context a bit later on, but I'm going to attend to just a few issues that I've got on a slide. If you can maybe just flip over to the next slide for context, is the parliamentary interaction since the forming of the Government of National Unity. I think everybody that is listening and took the time or the valuable time to listen to us this afternoon will realize that what we saw last week in Parliament wouldn't have happened if it wasn't a Government of National Unity. I think we can all agree that prior to the Government of National Unity, things in Parliament were a bit one-sided. I think the one and only victory that we can claim was when the benefit scheme bill was not passed in Parliament, with the necessary pressure and everybody that gave inputs at the time. I think apart from that, last week was probably the biggest victory for road crash victims and for all stakeholders in this arena that we operate and hold so dear, and which is misrepresented on so many levels by, with all due respect to the CEO, or currently just an employee of the Road Accident Fund, depending on what his future holds. But I think it's important that we take stock about the damage that was caused over the past 5 to 7 years since Mr. Letswalo was firstly appointed in before he was appointed on a permanent basis. And I think we can all speak to the fact that what we see in the form of mediation directives that are all channeled towards early settlement of matters, you know, it's in practice it's a good idea, but or in context it might be a good idea, but in practice I think everybody that deals in the RAF arena will know that on a practical level and financial level, it will simply not, in my view, be any consolation to any of our clients. So to just give it a bit of context, The mediation protocol that was introduced by Judge President Malambu, I think, was in main also fueled by a narrative that was pushed by the current suspended CEO of the Road Accident Fund, in that we as practitioners want matters to be prolonged to such an extent that we can obviously earn more fees at the end of the day. But I think everybody on this platform will agree that once a matter has been set down for trial and certified trial ready, there's nothing more than we can really do in terms of adding more fees to what we've already done at that particular point in time. So I think that is, with all due respect, a huge misconception that was introduced first in Parliament in August of last year as one of the reasons why we as lawyers prolong matters unduly. And I think with all the interactions that there were with the different professional bodies like the PAA and the JAA and all the Judge President, and it seems that the Road Accident Fund were also involved. I'm just not sure on which level, seeing that they don't have a legal officer, in attendance. I'm not exactly sure to what extent the formalities of the mediation protocol was finalized. And I think we all can agree that since the directive was implemented, it has been nothing more than a failure in terms of the Road Accident Fund's purported willingness to support mediation. I think we as practitioners are experiencing exactly the opposite. I think one of the unintended consequences of the board notice that we will get into a bit more detail is the fact, and something that, for all due respect, the Judge President maybe didn't take into account, was the fact that we are sitting with a parallel system of claims that was as a result of the introduction of the board notice. And what I mean with that is, obviously, and I think some of you might agree, that there are thousands of matters that have been lodged with the Road Accident Fund in terms of the Act in compliance, statutory compliance, which was sent back to us or returned due to the fact that they're not board notice compliant. But in fact, that what the Road Accident Fund didn't take into account, or maybe took into account, is that these claims are actually existing and they return in the form of a default judgment a few months later. And that is exactly one of the aspects that I don't think there's given much thought to, is the fact that you're sitting with probably most of the matters that are in the system and that are currently certified trial ready, that the Road Accident Fund has given instruction to the state attorney not to mediate on these matters. So that in itself is a fait accompli to the mediation directive in itself. So there's definitely a few challenges that we as practitioners are facing, and I'm happy to say that one of our colleagues, Mr. Stefan Spruits, got an application now early in June contesting the validity of this practice directive. I've seen of late that PIPLA has also filed an urgent application, which is going to be heard soon after that. And our own firm has embedded in all of this an earlier application on the directives, not necessarily pertaining to the mediation directive, but we brought an urgent application in February contesting the directive that was in ESA at that particular point in time. And we were told that the matter is not, it's not urgent, so we set it down on the unopposed roll, which is going to be heard on the 14th of July. So at least we as practitioners have 3 opportunities to have our concerns ventilated in court. Hopefully some sanity will prevail, or alternatively, at least we get a judgment so that we can take the matter further. From our point of view, we obviously also lodged an urgent application to the Constitutional Court, which I think that most of the attendees would know that we were denied direct access. And I think what we as practitioners must just have regard to, because, you know, I've seen a lot of comments on LinkedIn and, you know, people adding their voice to the application and giving opinions. You know, we've seen a judge even giving an opinion on the possible outcome of essentially our application. And what it boils down to is a simple question on whether or not, with all due respect, the Judge President is within his right to change the law or the rule by way of by implementing a directive. That is the simple question that needs to be answered, and hopefully with one of these three applications we'll have some indication or direction of what the courts think about that argument. And I'm just happy to see that it is going to be heard in the next week. So I think we should give all of our support to all the parties that are actually taking it upon themselves to drive this argument on mediation. And I think, you know, just to put things in perspective, it's not that we are against mediation as an alternative to dispute resolution. Personally, I just don't think that mediation should form part of the RAF context of settling and resolving matters. And I think everyone in this arena would know that the Road Accident Fund, as it is, simply doesn't have the resources to attend to the volumes of matters that would need mediation. One of my colleagues told me yesterday that apparently the Road Accident Fund instructed 3 individuals, not 3 institutions, only 3 people to as the mediators going forward. And you know, we are also not sure whether the Road Accident Fund has made a valid commitment towards paying that 15,000 Rand contribution to the whole mediation process. That still remains to be seen. So there's really a lot of loose ends that we would have hoped that would have been tied down before the implementation of this mediation directive. Our firm had a discussion with the South African Law Reform Commission specifically addressing the Road Accident Fund's situation in the mediation context. And, you know, all from our point of view, you know, mediation simply wouldn't work. Personally, I think, and we've already made certain proposals to Parliament on what we think would be a better outcome for road crash victims in terms of settling matters, and we're hoping to get an audience very soon to address it in in a more formalized basis. So that you know, we can get to a point that our clients' claims could be heard and settled earlier than hopefully 2031 or 2032, if we can somehow still retain those trial dates. So from a practical point of view, I think everybody's experienced the reality that mediation simply frustrates the process. It's just kicking the bucket down the road. And I think it's going to have exactly the opposite outcome of what the Honourable Judge President is intending with mediation as a form of dispute resolution. I just think that the climate isn't right for this kind of intervention. Financially, from a practitioner's point of view, and jumping to contingency fees 0.6 in RAF matters, I think every practitioner working on a contingency basis had already made the additional costing towards including mediation as an alternative, and I think everybody can agree that it's simply going to be too costly to drive this kind of resolution. So hopefully, you know, the courts will give us proper direction, and I think especially with the PIPLA application, if you have regard to the proper presentation that they've made in terms of the practical value and implication of mediation on the RAF format, I think everyone would agree that it simply couldn't work. Getting back to the board notice issue, I think everybody experiences the frustration of having to deal with this parallel system that we are confronted with at the moment. Even in my own firm, we've been lodging claims as if the board notice didn't exist. And obviously we've run through the motion of summoning the road accident fund after 120 days, getting court orders on default. And obviously I think many of you would agree, then you run into the obstruction at the payment process with the road accident fund, simply saying that that matter doesn't exist. From a practical point of view and personal point of view, I can discuss to our colleagues that I've taken the matter further with our friends in Parliament. I think at this point in view, their main concern is the issue regarding the accounting standard and the Auditor General's approach to the accounting standard that the Road Accident Fund is following. So I'm on a personal level trying to instill the earnest issue regarding the board notices implication on road crash victims, not just necessarily from a lodgement point of view, but also from a practical point of view and eventually the payment point of view as well. I know that some of our colleagues in the LPIIF matter are attending to the issue of the board notice on a formal basis, but I'm hoping that the Minister will grant us an audience so that we can discuss the implications of this and to show that the perils of what we see on the board notice has exactly the same, if not more value than what we see in the Auditor General's headache that they've got with the Road Accident Fund. So just from an interest point of view, for those of you that watched the SCOPA meeting of last week, a very important aspect that was raised there was the fact that neither the CEO or his board had been vetted. Now what that means from a practical point of view, and for those of you that did national service, you would know that you need to be vetted to be able to gain access to certain information, either secret or top secret or whatever the case might be. And having regard to the CEO's position, you would accept that he would need the highest possible rating in terms of vetting his his access to information. Now that hasn't been done, and I've recently obtained an opinion from one of our counsel that makes the argument that without that vetting, none of the executive decisions that Mr. Letswalo or his board made since he's been at the helm of the Road Accident Fund are lawful. And I think that I spoke to one of the councils that are involved in the LPIIF matter, and hopefully there's still time for them to also include that argument. Because if that is the case, then our headaches concerning the board notice and a few other aspects, including the past medical expenses that the Road Accident Fund is persisting in not paying foreigners, claims that are not being paid, and all of the other challenges that we are facing stemming from frivolous litigation that the Road Accident Fund has been involved in over the past few years. Hopefully that could be resolved much quicker than having to wait for either the SCA or the Constitutional Court eventually to make a decision on those matters, because I think everybody listening to this would just like to get back to the legal certainty of what we find in the Road Accident Fund Act itself. So hopefully there will be leeway made towards getting back to the basics of considering RAF matters in the context of the Road Accident Fund Act as we know it. So from my personal point of view, and I think everything that we do within the APRAF scenario, from a collegial point of view, you can accept that we're doing as much as we can on a platform that falls outside of the courts in terms of making sure that the people that are making the difficult decisions have the right information to ask the difficult questions. And I think the value of that we all saw last week, Wednesday, and subsequently what happened after that, and what is happening at the moment within the department in terms of the structure of the Road Accident Fund. And I think all of us, considering what is happening, should really throw our weight behind trying to assist in as far as we possibly can, and what would be allowed from the department side, and whether they would be willing to allow us to disclose information and our knowledge that we have, in this very sensitive arena that we operate in, to assist them in creating a better road accident fund and getting it to what it's been in the past, because it was really a center of excellence at a particular point in time. And I'm sure with everybody throwing their weight behind and their knowledge and experience and cooperating to a common goal, I think we can all achieve that eventually. It will take time. It's not a quick fix, but I think last week was a huge victory for everybody, and mainly for our clients, to address all the disparities that we've experienced over the past few years, subject to the current executive of the Road Accident Fund. So hopefully things will start getting better from here on end. So that's as far as I can contribute in that context. I will maybe ask Mr. De Bruin if there's one or two things that he would like to ask, and then obviously we will open the floor for a few questions if there are any specifics that you want to have more information about. Thank you, Peter. If there's anything that you would like to add.
Yes, maybe just in conclusion, just move to slide 6, please. And I'm not sure whether they've unmuted me. If I'm muted, can you unmute me? Kat, if you can comment, can you hear me? I'm not sure.
Good.
Peter, yes, I can hear you.
Okay, all right. Let me conclude with solutions going forward. The context of this, the RAF's current position, is a consequence of a failure of 3 spheres of government, starting with the executive branch, which means the Department of Transport, the RAF CEO and the board. Besides the CEO willfully trying into the ground. And I'm not a legal practitioner, so I can maybe be a more freer with my opinion. I'm an industrial psychologist. With a board that was in cahoots with him and didn't execute any of their fiduciary duties, and should be, as a consequence, hopefully be kept responsible. And then until Minister Creasy and the Deputy Minister in the Government of National Unity on Transport took over, 4 or 5 ministers in 2 previous parliamentary sessions did not do what they were supposed to do from an executive branch point of view. Further, it's been a failure of the legislature. We have many supporters and friends on the Portfolio Committee of Transport, and from all spheres of political parties participated tooth and nail to keep the RAF Act intact, to defeat the RABS Bill in Parliament. You've seen the 2024 RAF Amendment Bill being withdrawn earlier this year. This does not happen if there's working together between various political parties. And that's where APRAF, a little bit like the movie, The 300 Spartans, protecting that narrow, APRAF compete on budget or in numbers or in national press. but we can be in the corridors of Parliament and stop acts and legislation. And then lastly, there's been a total miscuing from the judiciary in terms of intervening in matters that is reaching too far, really assisting the RAF in an inappropriate manner, etc. And that is part of the solution. So where are we going from here? Before, and literally yesterday again to the Minister and the Deputy Minister of Transport. And this set of proposals focuses on the next 18 months, the next 3 years, and the next 5 years. We believe in 12 months from now, there can be a net saving of R500 million a month. Can you imagine if there's R500 million a month more to spend on claimants, to settling claims, to catch up the backlogs in terms of future mates and past mates, to focus on the claims that's not been. In terms of this illegal and unlawful board notice, about 90% of all claims are not part of the system, and that still needs funding. So all of that needs to be addressed. First of all, government on a national basis needs to have an integrated strategy to deal with road crashes and get us away from the third worst place in the world. A country worse than us is, for example, Syria and Lebanon. Now, that's not a very good place to be in the company. For example, the Alive Arrive action over Easter weekend, many would not know, is not a government enterprise. It is a private sector NGO. So even Arrive Alive, which we all link to road safety, is not done by government. So an integrated strategy is needed. Then the RAF Act needs to be amended. There's not much wrong with the Act. There's small jackals in the Act. There's oversight responsibilities needed. There's guardrails needed for the board and the RAF. And maybe one or two things that should be strengthened. But the problem is in the Act's application. Then the RAF to execute its mandate. This is one of the biggest failures from the Portfolio Committee on Transport, the board and the minister, that for some reason they never held this rogue CEO accountable for mismanaging 3.3 billion rand a month, acting as if it's his own organization and its own budget. That should never have happened. Fact is, Minister Creasy and the Deputy Minister didn't have a choice anymore and did the right thing by suspending him. And I think we've had feedback behind the scenes that there are some of the executives that's already started to resign, and may I be blunt and say the rats and mice are starting to leave the Titanic, which is good. Thereafter we need to save it. Then claims handler capacity and competence. More legally trained claims handler. They need to contest claims. This is how this act is written. Time years settlement of court. Of cases, create a settlement hub, which has been talked about a lot by my colleague, Mr. Gert Nel. More effective loss and support settlements, reduce the legal fees, about R1 billion a month wasted because incompetence has crept in the way they try and do settlements. Then regulate expert medical fees. I mean, we can't have, and I'll use myself an example, you can't have industrial psychology all over the place. I'm not saying it's higher, but it should be regulated. Then, big problem is we can fix and make the RAF a center of excellence, which can and will happen in 5 years. APRAF did not fight this battle for 11 years to give up now. Now our real work starts. The legal battles we've left for the legal fraternity. But what we've done is focus on make the law and the act survive to the point that we can start fixing it. So our work following a national 2018-19 leading up to COVID is coming to fruition now, that we are driving a 10-point plan to first stem the bleeding, then fix the basics, and then make it a center of excellence, what it used to be in the heyday 5 years ago. But even if we do that, the RAF would still not function properly without access to the courts and fairness from the judiciary. Therefore, as opposed to mediation, which is not binding, to court. They are not going to turn up for any mediation. This is just another hurdle of them having an excuse not to do something. So that has been bogus and nonsense from day one. The fact that it's been entertained is actually the bigger issue that's mind-boggling. A tribunal as almost a division of the court, equal to the labor court on a high court level, is obviously the answer. And there's been a lot of work done behind the scenes, and I can say that there is, in principle, support, and the DA and other GNU members on, for example, the Portfolio Committee on Transport, which supports this. This would be cost equal because judges who has an appetite for this or new ones to be appointed will simply be transferred to this court. Now, this is a longer term solution that will take some time. But can you imagine all the councils that's lost their work because of the lack of trial dates and the nonsense going on in the RAF and with the courts? If we are back on track, would basically make most councils in the medico legal third party law industry fully busy again, as it should be and as it is provided for in the Constitution. So we focus on the solutions going forward. We hope to call a national solutions conference this year still. You'll all hear about it. This organization will be party to that, where we will focus on all of these things. And this is what we are engaging Parliament about, and this is what we are engaging the judiciary about. I'm going to leave it there. You all must have a lot of questions. You are welcome to email. Sure the organizers have all the APRAF detail, but I'm handing back for questions and mostly to Mr. Gert Nel for all the technical stuff. Thank you for listening.
Thank you very much, Peter. From my side, a favor that I would like to ask my colleagues attending this, anyone that is operating in the RAF arena, we are busy realigning our application or our original application that we filed at the Constitutional Court because we want to refile it here in the North Gauteng High Court, and we are hoping that we can get some statistics from our colleagues in terms of matters that they would potentially lose trial dates on. So I would really like to invite you, if you are prepared to do that, to share that information with me so that we can include it in as a basis for the application that we intend to file in a week or two's time. So if you are willing to share that information, I would really appreciate as many of you to get on board, give us an indication of where you were in terms of trial dates before the implementation of this mandatory directive on mediation, as opposed to the potential risk that you have now to lose those trial dates. So if you would be willing to share that with me, we will, my details would be available from the organizers. If you would be willing to drop me an email with the details, it doesn't have to be today. You can share it maybe by Friday. I would be very happy and keen to see how many of you would be willing to get on board so that we can put the best possible application before court, subject to what's going to happen to Mr. Spruit's and Pipla's application in the next week or two. But barring that, obviously, we would have to use all of our options to try and push the issue concerning the workability of this directive. So if you would be kind enough to share that information, we will really appreciate that. But that being said, Peter, thank you so much for your input. And if there's any questions you would like to ask, now's the time to do so. Kabelo, if there's still time for that. If there are any of the participants that wants to ask a few questions, or alternatively, you can always send me an email or to Mr. De Bruin afterwards if there's anything in particular that you would like to have a bit more information on. Thank you very much.
Yes, Mr. Nel, if you can stay on, and I'll ask Mr. Thembekosingcobo to take us through the questions and comments that came through our chat. Thank you very much.
Thank you so much, Kabelo. Good afternoon, colleagues, Mr. Nel and Mr. De Bruin, and our Free State Director. I'm not going to waste too much of your time, but before I start with the questions, I just want to grab this opportunity and remind legal practitioners in attendance that there is library services that is accessible at no cost for legal practitioners. I'm saying this in order to also try and assist. There is a very burning issue which touches on the usage of ChatGPT for case law references. So I wish to encourage legal practitioners in attendance to try and verify, use the library services to verify the validity of those citations. So it's just a matter of sending us an email, giving us the full citation, then we'll be able to check whether that is exactly an existing case law or it's just a fake. So please don't miss this opportunity, because there's been a lot of complaints from different courts in South Africa about the usage of cases coming from the very same chatbots. So now going straight to your questions. The first question is that I used to work at Ernst & Young processing road accident fund claims. We used to settle 1,000 claims a month. Road accident fund settles 1,000 claims a year. Our project was terminated. Road accident fund does not want to settle the claims. We had a system that was quick and easy to use. So I'm not too sure whether this is a comment or a question, Mr. Nel.
I can just maybe comment on that, and I think the value of the information shared by the attendee is, if the viewers have any suggestions in terms of the bettering of the system that we are dealing with currently, I invite them to share that with me. Just as a point of reference, I worked at the Road Accident Fund in the 90s, and that was in my mind, the best structure that the Road Accident Fund, or the MMF as it was known at that point, had in terms of settling claims. I mean, you were called into your manager's office if you received the summons in your department, because you were expected to settle matters within 120 days. So litigation was very few and far in between. And I really think that kind of a system it's not a pipe dream, it's been done before. So we don't need to reinvent the wheel. There is an existing system that we can introduce and propose to the people that are going to make the decisions at the end of the day in terms of the way forward in the Road Accident Fund. But I think we need to give our support and extend a helping hand in terms of making things work for everybody involved, and mainly for the victims that we represent. So thank you for that. And again, if anybody wants to share any positive reform idea, please share that with me on email, and we can include that in the bundle that we're going to propose to the department and taking the matter further. Thank you.
Thank you so much, Mr. Nel. Another question is that, hi, I am a practitioner from Limpopo province. I want to know the threshold when administrator of attorney's trust account is required to use professional auditor.
Thank you, Bututembi Nkosi.
Yes.
Am I audible?
Yes, you are.
Thank you. The moment you are operating a trust account, you must use an auditor to audit your trust account on an annual basis if you're already in existence, or for the first 4 months of your firm, and it must be a registered auditor with IRBA. Unfortunately, your audit account or your trust accounts cannot be audited by someone else than a registered auditor. Thank you.
All right, thank you so much, Maggie. The next question is coming from Mr. Haban Thomas from the LPIIF. It goes like, hi, Mr. Gert. Our challenge of the board notice 271 of 2022 and that of Adams and Adams against board notice 58 respectively continue in the Supreme Court of Appeal. We expect a long, though, fight ahead as Stalingrad approach is adopted in opposition. My question is whether plaintiffs can use the substantial compliance cases in the interim to overcome reliance on the impugned board notices. I covered some of the successful recent cases in that regard in the March Risk Alert Bulletin. I think this is yours, Mr. Nel.
Yes, Mr. Arden, from my point of view, and we've maintained this approach from the beginning, you know, and I simply break it down to what is in law. We all know what the Road Accident Fund Act says and what it requires. In terms of the Road Accident Fund Act, you only need to submit to an affidavit and a medical report to be substantially compliant. Anything over and above that is a bonus to the Road Accident Fund, or if you really want to have regard to case law, that you should only be able to put the claims handler in a position to reasonably assess your claim and make a determination on a proposed offer. So I think the point, you know, is very similar to what we've seen in the discovery matter, is that the actual point in law has been fudged to such an extent that everybody now is none the wiser as to what the correct approach should be. So my personal point of view, and it might not be law as far as, but then again, it is law, is the fact that the Road Accident Fund Act, as it is, stipulates those two requirements. The board notice has been found unlawful in all of the instances that it has been heard. The mere fact that the Road Accident Fund is taking the matter to the SCA, I think is just going to rubber stamp what the lower courts has already decided on. I think it's very similar to the Auditor General's argument. All of these arguments exactly the same with our fight concerning the mandatory mediation, is whether or not an executive has the authority to change the law through a directive or a board notice. Simply speaking, I don't think it is lawful to do it that way. So, Mr. Harden, I think with a long story short, from my point of view, and I've never had any concerns from the court or from the bench in the way that we've been submitting claims to the Road Accident Fund, getting default judgments on matters that we have submitted in terms of the Act, even though it's not board notice compliant. We even went as far as building into our court orders a term or an order that the Road Accident Fund is compelled to register the claim, even though it's not board notice compliant. So I think at this point in time, we must, you know, we must all face the reality that it is simply impossible to comply with the board notice. Now, it's by design. So I think we should bring things back to where the basics, and that is the Road Accident Fund Act in itself. It stipulates the process of lodging a claim in the Act and not even in the regulation. So that to me is the law, and that is the line to be followed. Is the board notice to me is a non-issue, and it's unfortunate that the executive of the Road Accident Fund is prolonging their argument and expending the amount of money similar to the Auditor General's campaign against the Road Accident Fund. We all saw it last week in Parliament, that what the Deputy Minister's attitude is. We've seen in previous SCOPA meetings that the Minister has also expressed the view that the Road Accident Fund should stop this litigation. And it's a similar argument to the board notice. So that is, in my mind, is going to follow the same route. And hopefully, if there is a change in guard at the Road Accident Fund, sanity will prevail and we will return to a normal state of affairs, dealing with these matters within the four corners of the Road Accident Fund as we know it, or Road Accident Fund Act.
Okay, thank you, Mr. Nel. The next question, can you lodge a claim against Road Accident Fund with only an affidavit from the hospital and assessment reports from experts and the claim be successful?
Well, you should also include an affidavit from the plaintiff or the injured person as to the merits in terms of Section 19F. It's debatable whether an affidavit, as long as I would presume that it has to be a statutory medical report, because that is what the Act requires. So in my mind, if you break the requirements down, it needs to be an affidavit and a statutory medical report. And depending on whether or not it's the first hospital or whether it's a later medical practitioner that has to complete the report, maybe due to the fact that the original doctor is not available anymore. Obviously, there are ways and means to deal with that. So if the person that posted the question wants a bit more detail on that, they're welcome to send me an email and we can attend to that.
Okay, thank you. The next question, is it possible for Road Accident Fund claim to take over 10 years to settle? The accident occurred 13 years ago and the client still hasn't received a date or came any closer to payment?
Unfortunately, yes, it can take so long, and having regard to the new directive on mediation, it can take even longer. Unfortunately, I think that is the reality of what we're dealing with, and that is the importance of successfully attacking this directive on mandatory mediation. But yes, there are matters, but in my experience, it is rather the exception than the rule.
Okay, thank you, Mr. Nel. And how do I get a claim launched if Road Accident Fund refuses to accept lodgement, as they require a final award from the Compensation Commissioner, which takes years if one gets it at all?
Well, as far as the lodgement is concerned, rather just lodge the claim through registered post so that you have proof that you have submitted the claim, or use the sheriff to deliver your claim. But as far as the final award is concerned, I fear that you're going to have to get that prior to the Road Accident Fund making an offer. And there are people out there that chase those kind of final awards. So I'm sure that if the person that posted the question does a bit of research, I'm sure they'll find somebody that would be able to assist them in getting that final award.
Okay. The next one, in case that the High Court has done away with default judgments against the Road Accident Fund, what options are there available to plaintiff attorney to finalize their matters in case at N?
That's an interesting turn of events. The first time I've heard of it. We do work in Durban, and I've not seen that or heard that that is the current state of affairs. And you know, in all fairness, I can't really see why that should be the case. I would really like to get a bit more information on that. It's the first time that I've ever heard of that.
Okay. What do I do when the Road Accident Fund in Cape Town physically refuses to accept a claim that is substantively valid? Do I simply post it by registered mail?
Yes, you send it by registered mail, or you send the sheriff to go and deliver it at the Road Accident Fund. And then unfortunately it would fall within the scope of one of these ghost claims that will resurface and haunt the Road Accident Fund as a default judgment at the end of the day. And that is my main concern with the current state of affairs, is that the Road Accident Fund or the department are allowing this parallel system to continue subject to this board notice. And that's really a huge concern to me. And hence I'm making a lot of work and you know, in trying to convince the department that they should attend to this on an urgent basis, because this is it's gonna result in a huge embarrassment to the department, and also, you know, just considering the fraudulent aspects of some of these claims that might enter into the road accident fund arena without being checked by the fund. So this is definitely something that the department should have urgent or give urgent attention to.
Okay. Mr. Nel, this one wish to know as to how you're dealing with orders that are not being paid because the road accident fund claims were not lodged properly.
At this point in time, we are, you know, as ridiculous as it sounds, we're relodging these claims after we've because I think everybody that's listening at the moment is experiencing this. The matter is that we can still relodge to make it board notice compliant, because you need a link number to be able to get payment. And this is obviously one of those headaches that we are again trying to bring to the attention to Parliament, is the challenge that the victims are having now, considering the unlawful board notice and the fact that victims are being excluded in the first place. And when they're lucky enough to get a court order that in terms of this unlawful board notice, they're not getting paid. So the unfortunate reality is at the moment, the Road Accident Fund is simply not paying those matters, subject to what they consider to be compliance with the board notice. But, you know, we are obviously trying to execute, and I think many of you have tried that. Writs of execution doesn't help. So I think, you know, we need to make a lot of noise around the practical implication of what this board notice is causing. You know, and I think Mr. Harden from the LPIIF, I think that must be one of your biggest headaches, having to deal with this challenge. But I'm sure, again, and I'm hoping that with the changing of the guard, we will be able to go back to normality and practice in accordance with the Road Accident Fund Act as it is required. And but obviously that's going to need a bit of work, and colleagues, we're definitely doing what we can to make sure that everybody that's prepared to listen and can make a change is attending to this at the moment.
Okay. I'm not too sure whether you're going to be able to assist with this one. This legal practitioner is based in KZN in Pietermaritzburg. He's saying that for the past 5 months, I've noticed that the Road Accident Fund has been rejecting general damages for all my head injury claims and quick to give an offer on LOE. And because we have waited almost 2 years to go to trial, the claimant also get frustrated, and they don't even want to hear the fact that you want to appeal at the HPCSA. And as a result, we find ourselves having to answer to complaints filed at the LPC.
Again, that is an unfortunate reality of this dictatorship that we've seen under the management of Mr. Letswalo and his board. And the unfortunate reality is that with all the negative remarks that has been made about practitioners over the years, you know, clients do tend to become, you know, discouraged about what is happening. But I think, you know, we need to deal with what we have at the moment. As Peter mentioned earlier, I think that things will be better soon. Well, not soon, but things will change. And hopefully, you know, we'll be able to get some normality back in terms of just managing the claims as they should, you know, including general damages. That's been an old angle that the Road Accident Fund is taking, just to kick liability and payments down the road. You know, obviously we all know that they're trying their level best to pay as less as possible, and this is just one of the ploys that they're exhibiting. So communication with our clients, unfortunately, remains key. And I think working with the LPC to the extent that we're doing at the moment, to also inform them of the realities that we as practitioners are having to deal with on a daily basis, I think is also important, to have a working relationship between ourselves and the LPC, so that everybody is on the same page in terms of the expectation. If I may, Kabelo, just get back to the previous question in terms of non-payment of matters that are not board notice compliant. If I may, in addition to my earlier request, ask colleagues to also maybe share a list of matters that they have that are ML matters or whatever, the Road Accident Fund describe those matters when you lodged your claim. You don't have to mention any figures in terms of the value of the matters that you've settled. If you are willing just to share, the details of those matters to the extent that you would feel comfortable in sharing information with my firm, because I think that is an important issue that we should put before Parliament as well, to show the extent of this management by the Road Accident Fund, because as we are sitting here, I think nobody really knows, and more importantly, the Auditor General doesn't have an idea of what the contingent liability of the Road Accident Fund is, considering these matters that are actually statutory compliant but not board notice compliant. So if you would be willing to share information on the how many of these matters you have in your system that the Road Accident Fund is not attending to payment, share that with me, because that will obviously bolster our approach and obviously give a bit more credibility to the information that we share to our friends in Parliament, so that they can address this issue earnestly. Thank you.
All right. The next one, Mr. Nel, this legal practitioner saying that we were able to settle claims without having no issue, without having to issue summons to recover cost, as per Act 54 of 56 of 1996. The Amendment Act changed all that and forced practitioners to take the first necessary step of litigation by having to issue summons to recover cost. Is this not an unnecessary step and something that needs to be revisited?
It's an interesting point, and we have raised that with the department, and that falls into what Peter has earlier described as our solutions or the proposals that we made, is that the whole issue of when lawyers, because as the Act is, it's incentivizing litigation, and I think if we can make proposals in terms of an amendment, as it's been before the 2008 amendment, that the costs or the party and party costs are being paid from an earlier point of view than summons, I think attorneys would focus a lot more on lodging the claims with as much detail as possible in order to ensure that the necessary is done prior to settlement of the matter. And that is definitely a very good point, is that there needs to be a real look at the costs, and as to not to incentivize the litigation process itself, but rather to focus on the settlement or the early settlement of matters. So that is definitely a very good point that you've made. We've already addressed that in our solutions. Thank you.
Okay. Mr. Nel, with your permission, can I ask Kabelo to display your email address?
Yes, certainly. You're more than welcome to do that.
Yeah, because I think we won't be able to cover all the questions that have been raised here within this short space of time. So I think it would be better if the legal practitioners can have your email address so that they can make contact with you separately.
Certainly, you're welcome to do that. Just as a matter of formality, how much time have we got left for questions?
I think we have 5 minutes because we're supposed to close at 3:30. We can still take few, eh?
Okay.
Yeah. Okay. Good day. In one matter, I'm dealing with the Road Accident Fund. The Road Accident Fund made an offer on all heads of damages claimed, and the offer was made an order of court. The Road Accident Fund was supposed to pay within 180 days. and the plaintiff died about 2 months before 180 days expired. Now the road accident fund and now refuses to pay and say that the LOE must be calculated until the date of death of the claimant. Is that allowed in law? And what must be done further? I instructed Sheriff to attach, but the Sheriff is unable for some reasons to recover the monies, and the matter is currently more than 700 days after 180 days.
No, it's unlawful, and it's again one of those opportunistic cost-saving exercises that we've seen the well, what should we call him? The employee of the Road Accident Fund, Mr. Letswalu. You know, this is one of the ploys that is implemented to reduce the liability. Obviously, once there's a court order, it is what it is. The Road Accident Fund will have to file an application for rescission, which will in all probability fail. So in law, they have to pay. But these are the kind of examples that I think our friends in Parliament would be interested in. So again, I would invite this colleague of mine to send me the details, send me a proper breakdown of your matter and the concern, so that we can raise this and ask whoever is going to attend at the head of the Road Accident Fund in the next meeting at Parliament, so that we can ask them these difficult questions, so that we can hear firsthand what their opinion is on that.
Okay. I see many of the questions here touch on the board notices. So like this one, in East London, they turned back many files saying that they are not in compliance with the board notice, and unfortunately they may prescribe in our hands. Is there any remedy to this? Yes,
I would invite and really advise colleagues, just lodge those claims either through the sheriff. There has been case law on that, so you're allowed to do that. It might be a bit of a costly exercise, but to cover your own interests in terms of liability, make that effort, or alternatively, just lodge the claim through registered post, as long as you've got proof that the matter has been served or lodged with the Road Accident Fund, then the prescription is stayed. And, you know, so yeah, just make sure, don't sit on these matters, don't dwell on having to comply with the board notice, because I think everybody that tried that exercise, we've even submitted that board notice in Parliament with the additional requirements to a portfolio committee, and none of those members were able to even, you know, commit to understand exactly what it requires and the extent that is required. So there's no way that you can deal reasonably with that. So just make sure the matters that you do file are statutory compliant, and just make sure that you do it in terms of what the Act requires, either through the registered post or of late through the sheriff. Just make sure that you've got proof that you've done that.
Okay. Is the pre-assessment letter that we received from the Road Accident Fund, when trying to physically lodge enough for you to issue summons, even though the documents were not accepted by the Road Accident Fund? And what special plea can Road Accident Fund raise against those summons, and how can one deal with them?
I would again, you know, to engage the Road Accident Fund in a pre-assessment, I think it's a noble gesture. But in terms of the Act, the Act doesn't make provision for pre-assessment. So that in itself is already an unlawful exercise. So to base the lodgement of your claim on an unlawful exercise by the Road Accident Fund, just give them the opportunity to raise a special plea. Because, you know, we have to be mindful of the fact that who we're dealing with. You know, tomorrow, you know, today we're dealing with one head of the department, tomorrow it's somebody else, and they have a different feeling, or we tuck the matters or the Road Accident Fund process back to what it should be, and the next person says, no, but pre-assessment is not a requirement, so we don't accept your claim as being validly lodged. just stick to the basics of what the Act requires. Make sure that you lodge it via registered post, that you've got that postage stamp to show that you've done that, or the return of service by the sheriff. Anything else than that, you're going to put yourself at risk. So please don't go there. Make sure that you stick to the basics of what the law requires. Don't assume that you have complied, and definitely don't bank your liability on what the Road Accident Fund requires you to do, because at this point in time, for all due respect, anything that they do is unlawful. So make sure that your side of this story is clean, and in terms of what the Road Accident Fund requires. With a long story short, it might be proof that you were there on the day and that you tried to lodge the claim, but if it was up to me, I'll just relodge the claim through the sheriff and sit out the 120 days and just summons.
Two last more questions, then I'll hand it back to Kabelo. Would it not assist us to proceed and compel Road Accident Fund to mediate and share the experiences as we advance changes to the legislation?
I would really like to see this person succeeding in getting the Road Accident Fund to mediation. I think if that happens, it's going to be a glorious day. But in all fairness and with all due respect, that's not going to happen. I mean, if the Road Accident Fund doesn't even turn up for their own applications, from what I've experienced, they'll definitely not pitch for mediation. They simply don't have the resources. They haven't committed anywhere in writing that they're going to pay for this mediation. And I don't know who of you have got the financial resources to cover plaintiff and defendant side of mediation. It simply is a pipe dream, and hopefully, my colleagues that have filed these applications in court will bring some justification to this argument, because mediation would simply not work in the RAF scenario. And I say that with the utmost respect to my colleagues who made the effort of qualifying themselves as mediators. Good luck with that. I can't see that happening.
Okay. For compliance with the Act, is it safe to use the old form, or do we use the new form but in line with the Road Accident Fund Act?
My approach simply is to cover both aspects of it. We lodge our claims based upon the old and the new format, and just to make sure that we make sure that we tick all the boxes in terms of what the form's requirements are. So I would suggest that you do the same.
Mr. Nel, thank you so much. I think I'll now have to hand it back to Kabelo. Kabelo?
Thank you, Mr. Ngobo. Thank you very much to all our presenters this afternoon, Ms. Margarette Kwakye, Mr. Peter de Bruin, Mr. Gert Nel, and thank you, the attendees of today's webinar. We love having these webinars where information can be shared. And if you have any suggestions for us, please send us an email on info@lpc.org.za. Have a wonderful afternoon, and thank you very much for joining us this afternoon.
Thank you. Thank you very much, Kabelo. Thank you.